In this video, we're going to break down Section 26, Liquidated Damages, one of the most important and most misunderstood parts of the contract. The Liquidated Damages section 1 explains what happens to the buyer's deposit if the buyer defaults. 2 outlines how much the seller may retain under the Liquidated Damages provision. 3 covers the 3% rule for 1 to 4 unit residential properties the buyer intends to occupy. 4 clarifies why escrow cannot release funds without mutual written instructions or a court/arbitration order. 5 reviews the special requirements for increased deposits, including the need for a separate liquidated damages agreement. By the end of this video, you'll understand exactly how liquidated damages work, what buyers are agreeing to when they initial this paragraph, and how to handle deposit disputes correctly in a real estate transaction. Let's get started with Section 26. 1. What liquidated damages means. A. Liquidated damages equals an amount the parties agree to in advance as a reasonable estimate of the seller's damages if the buyer defaults and fails to complete the purchase. B. Instead of going to court to prove actual damages, the contract says, if buyer defaults, seller keeps the deposit actually paid up to legal limits as the agreed-upon damages. This clause only applies if buyer is at fault and fails to close. It does not apply if the seller breaches or if buyer cancels properly under a contingency. 2. Initials equals agreement to liquidated damages. At the top it says, by initialing in the space below, you are agreeing to liquidated damages. 1. Buyer and seller must both initial this paragraph for it to be effective. 2. If either side does not initial, then liquidated damages are not agreed, and the seller would have to pursue actual damages instead, through court/arbitration, if there's a dispute. Never let clients initial this casually. Explain what they're agreeing to, especially the buyer, because it's their deposit at risk. 3. If buyer defaults, seller keeps the deposit actually paid. Main sentence, if buyer fails to complete this purchase because of buyer's default, seller shall retain, as liquidated damages, the deposit actually paid. Breakdown. 1. Buyer must have defaulted, failed to perform, no valid contingency, etc. 2. Only the deposit that has actually been paid into escrow is subject to being retained, the initial deposit plus any increased deposits that have actually been made. No payment equals nothing to retain, but buyer can still be liable for other damages if LD isn't effective. 4. The 3% cap for owner-occupied 1 to 4 units. Next part. If the property is a dwelling with no more than 4 units, one of which buyer intends to occupy, then the amount retained shall be no more than 3% of the purchase price. Any excess shall be returned to buyer. So, if all of the following are true, 1. Property is 1 to 4 residential units, and 2. Buyer intends to occupy one of the units as their home, then seller may keep up to 3% of the purchase price as liquidated damages. If the total deposits exceed 3%, anything over 3% must be returned to buyer. If the property is not 1 to 4 units or not owner-occupied, e.g., 5-unit building, pure investment, different rules can apply and a court could look at reasonableness of the deposit. 5. Release of funds is not automatic. The clause continues, release of funds will require mutual, signed release instructions from both buyer and seller, judicial decision, or arbitration award. Meaning, 1. Even if the contract says seller is entitled to the deposit as liquidated damages, escrow cannot just hand the money to seller on its own. 2. Escrow needs either a written, signed instruction from both parties or a court order or arbitration award directing who gets the money. Why this matters? If buyer and seller disagree about who defaulted, the deposit can sit in escrow until they reach a settlement and sign mutual instructions, or a judge/arbitrator decides. Liquidated damages doesn't mean automatic deposit to seller, it means this is the amount they can claim, subject to mutual instructions or legal decision. 6. Increased deposits require a separate LD form last sentence, often overlooked. At the time of any increased deposit, buyer and seller shall sign a separate liquidated damages provision incorporating the increased deposit AS liquidated damages, CAR form did. Breakdown. 1. When buyer makes an increased deposit, for example, per paragraph 5C/3D2, you must also have buyer and seller sign CAR Form DID deposit increase addendum, including a liquidated damages provision. 2. Without that separate LD provision, the increased portion may not be covered by the original LD agreement, and seller may have to prove actual damages to claim that extra money. Whenever a deposit increases, 1. Update the RPA or use Form DID. 2. Get both parties' initials specifically agreeing that the new total deposit is subject to liquidated damages. 7. When does this clause not apply? 1. If buyer properly cancels under a still active contingency, loan, appraisal, investigations, etc., LD does not apply. Buyer usually gets the deposit back, subject to contract terms. 2. If seller is the one who breaches, refuses to perform, doesn't deliver clear title, etc., LD is not a shield. Buyer can pursue other remedies. 3. If buyer and seller do not initial this paragraph, then there is no liquidated damages clause. Disputes over the deposit are resolved under general contract and damage principles.